Get ready. Start. 26. The above facts are borne out from the evidence on the record, and on the basis of these facts, the departmental authorities, keeping in view the fact that the actions of the respondent were considered to be subversive of good discipline and not conducive to proper working in the appellant organization, where there were a number of female employees, comma, took action against the respondent and removed him from service. Stop. The High Court appears to have overlooked the settled position that in departmental proceedings, comma, the disciplinary authority is the sole judge of facts, and in case an appeal is presented to the appellate authority, comma, the appellate authority has also the power and jurisdiction to reappreciate the evidence and come to its conclusion on facts, being the sole fact finding authorities. Stop. Once findings of fact based on appreciation of evidence are recorded, comma, the High Court in writ jurisdiction may not normally interfere with those factual findings unless it finds that the recorded findings were based either on no evidence or that the findings were wholly perverse and oblique or legally untenable. Stop. The adequacy or inadequacy of the evidence is not permitted to be canvassed before the High Court. Stop. Since the High Court does not sit as an appellate authority over the factual findings recorded during departmental proceedings while exercising the power of judicial review, comma, the High Court cannot, normally speaking, substitute its own conclusion with regard to the guilt of the delinquent for that of the departmental authorities. Stop. Para change. 27. Even insofar as imposition of penalty or punishment is concerned, comma, unless the punishment or penalty imposed by the disciplinary or the departmental appellate authority, comma, is either impermissible or such that it shocks the conscience of the High Court, comma, it should not normally substitute its own opinion and impose some other punishment or penalty. Stop. Both the learned single judge and the division bench of the High Court, comma, it appears, comma, ignored the well settled principle that even though judicial review of administrative action must remain flexible and its dimension not closed, comma, yet the court in exercise of the power of judicial review is not not concerned with the correctness of the findings of fact on the basis of which the orders are made, so long as those findings are reasonably supported by evidence and have been arrived at through proceedings which cannot be faulted with for procedural illegalities or irregularities, which vitiate the process by which the decision was arrived at. Stop. Judicial review, it must be remembered, is directed not against the decision but is confined to the examination of the decision making process. Stop. The purpose of judicial review is to ensure that the individual receives fair treatment and not to ensure that the authority, after according fair treatment, reaches on a matter which it is authorized by law to decide for itself, a conclusion which is correct in the eyes of the court. Stop. An appellate order, if it is in agreement with that of the disciplinary authority, may not be a speaking order, but the authority passing the same must show that there had been proper application of mind on his part as regard the compliance of the requirements of law while exercising his jurisdiction under Rule 37 of the rules. Stop. Thank you.